The next speaker that we have is Professor Dan Blanca from Marquette University Law School. I asked Dan if he would come and talk about hearsay, because it's probably one of the most difficult things to teach, even at the law school level. And we haven't really had a problem that's had much hearsay in the last couple years, but this one does have some hearsay in it. I also asked him to come because not only, as Nathan already gave the commercial for Dan earlier, so I'm not going to repeat it, and it would embarrass Dan if I did anyway, but...
Well, thank you, Nathan. Hearsay, but...
But Dan is not only very well versed in evidence rules, he also has been a mock trial attorney coach. So he has some idea of what we're talking about when we say teaching hearsay to high school students. So I'm going to let Dan go ahead and help us out here.
Thank you, Ellen. I very much appreciate this opportunity to talk to you, even if it is about hearsay. One of the less pleasant things to discuss, as Ellen indicated, I, for a number of years, was the kind of attorney coach, I guess you'd call it, for Greendale High School in Milwaukee. My youngest son, Steve, got very interested in this as a sophomore, and so after a year or so of assisting, I took over the reins. And I don't know what this perhaps says about me and the ability to inspire that son, but after 3 years of my tutelage in moot court competition, he's in medical school, and he's getting a PhD in genetics. So he had some interest, but they pulled him in a very different direction. This afternoon, what I want to talk about is teaching hearsay. And it's really more about how to teach, I think, teaching hearsay, because part of the challenge that we have is to make this all comprehensible to and interesting to high school students. And honestly, that's initially that's what drew me into into competition coaching. Is I very much like the opportunity to talk to the high school students, and the challenge really of trying to make this somewhat understandable and meaningful to them. I'm acutely aware that there's a lot of trial talent in this room, but let me ask you, how many of you are not lawyers? Okay, so a fair number. I should probably apologize for this subject in advance, but hearsay can be enormously technical. As Ellen indicated, it's oftentimes one of the least favorite parts of the evidence syllabus for law students, but just to assure you that you're not alone if some of this seems a little bit mystical or abstract, is I teach judges maybe 4 or 5 days every year, continuing legal education. And in fact, we did a 2.5-day workshop on civil evidence, civil litigation for the trial judges in June. And one of the things that judges always want is at least 3 or 4 hours on hearsay. And these are judges, all right, who deal with this all the time, who've come to the bench with a background in law and or oftentimes in trial law. And I say that just to assure you that for all of us, we find this challenging. And but the more we talk about it, the more we use it, the better. Finally, what I encourage you to do is ask questions, either about something I say in general or even about the trial materials. Can I assume that everybody has a copy of the trial problem? Is that correct? Yay, nay? Oh, okay, good. Because a little bit later on, if things go well, I do intend to use some examples, just a couple examples out of the trial problem. I think that this whole idea of teaching hearsay gives us just a tremendous opportunity to introduce the students to the trial process, and in particular to the adversary system. And that's because when we think about it, what is hearsay? And the reason we have the hearsay rule is because our trial system, unlike the continental system in Europe, is built on Viva Voce testimony, which is to say that what we expect our witnesses to do is to show up live, in person, and to speak face-to-face with the jurors, before the judge, with the lawyers. And the idea here of Viva Voce testimony is we want our evidence fresh, all right? It's like going to the store. We want fresh vegetables, fresh meat, fresh fish. Well, what we want in the courtroom is we want fresh personal knowledge. And we bring the witnesses into court, and if this chair to my right is the witness chair, we would have that witness sit down, and we would ask that witness questions about what he or she may have observed. But the theory here is that when they give their sworn testimony, because the first thing that happens with any witness is that they are sworn to tell the truth and the whole truth, is what they are doing is they are relating what they remember having observed. And they're trying to describe those memories in as accurate a fashion as possible. And all of this is important for understanding hearsay, because the larger idea here is that what they may have said before to other people, to investigators, to lawyers, even to other courts and other court proceedings, we don't care. Oh, yeah, we do care. But the idea is that we want this witness's memory here and now to be fresh. We want them to describe whatever it is that that they have observed. Now, the reason I belabor this is I think it's important. To me, it's interesting. I also, in addition to being a lawyer and a legal academic, I'm also a historian. And one of the things that I enjoy writing about and researching about more than anything is the history of the trial, particularly how the trial has evolved from the 1700s to the complexities that we see today. And one of the constants throughout there is really the hearsay rule. And even if we go back into the 1700s, when there were no lawyers who appeared with any regularity, especially in the criminal courts, what we would see the judges doing is the judges themselves would question the witnesses to probe what they saw, what they remembered. But so the trial is something that's very old, and I think that one of the things to stress with these students is this idea of viva voce testimony. That is to say that what we're trying to do with these witnesses is to capture their memories, what they saw firsthand. Now, this becomes difficult with any moot court problem. Why? Because they don't know anything. They have no personal knowledge. They, what they know about the case is what they've read in this script. And so if they're coming into this case, what they know is if I'm playing the role of for example, Carrie Agos, that what I need to do is to memorize this statement so that I can come into court and regurgitate it. So what's missing here is actual personal knowledge. And I think that it might be useful, at least, for you in coaching the students to talk a little bit about that, and to say that one of the features of any kind of a moot court exercise like this is that we don't have witnesses with personal knowledge. You do have to memorize these. Scripts, and I think that feature alone makes it more challenging for us to get at the nub of the problem of hearsay. So for example, if I were to ask, did you drive here today, ma'am? No? Did you walk here, or? But Scott, did you drive here today?
Yes, Professor.
All right. And what kind of car did you drive here in?
Honda Accord.
And did you come from Milwaukee? See, in a real case, what I could do is to continue this examination and ask Scott, when did you leave? Who did you come here with, if anyone? What kind of car do you have? What's the age? What's the, the model number on it? What route did you take? And I assume Scott would tell me he took westbound 94, just like I did earlier this afternoon. But the point is that Scott, like any of us, would be drawing from personal knowledge. Okay, what time did I get up this morning? What, if anything, did I have for breakfast? What's the next thing I did? What's the next thing I did? The problem for the high school students is that they don't have any of that. They got to come in here with this script committed to memories. So what I want us to do is to appreciate that artificial feature, the necessary artificial feature of this exercise, but also to work with it. I think it's also important to stress to students that you got to stay in role here, and that should, for example, you have a lapse of memory, because you're dealing with fake people, fake events, fake places, and the like, they will forget. But then the onus is going to be on the student lawyers to refresh their recollection. Because one of the things I like to tell my evidence students is that trial's a closed book examination. When the witness takes the stand, the witness doesn't bring any paper with him or her, except in the off chance that we have an expert witness, which isn't really our problem here. And so when that witness takes the stand, sans notes, sans records, and gets stuck on something, it's not a disaster. Yeah, there will be a fair amount of giggling and nervous laughter, and now what do we do? But what we know as good lawyers, what we do is we can use the witness's statement, or even other statements, to refresh the memory of this witness, and I'll talk about that more in a bit. But my primary point for right now is to appreciate that, first and foremost, this packet is the source of the fictional personal knowledge that our witnesses have. But more than that, this packet can be a source of evidence at trial, and all of the major witnesses in this case have made one or more statements. We have an affidavit of Rashawn Anderson. We have an affidavit of Detective Carrie Agos. We have a police report that is filed by Carrie Agos. We have an affidavit by an Avery Logan. We have an affidavit of Leslie St. Peter, although I know there's some really good criminal lawyers in this room. Not clear to me why we've got an affidavit from the defendant, but that's part of the, that would be ineffective assistance of counsel in the real world, but at any rate, we have that as part of our materials. And we also have an affidavit of Morgan Mansfield. And I think a teaching point that I would suggest to you is to talk a little bit about affidavits and what they are, because they're sworn statements. And any kind of a sworn statement is subject to prosecution if it contains any falsehoods. But the real teaching point is to contrast these prior sworn statements with the witness's in-court testimony, because that's also sworn. And that will also be punished if there are any material deliberate falsehoods. But what the students should understand is, at least in terms of the hearsay rule, is there's a world of difference between the in-court testimony, fine, our prized form of evidence, and these statements other than while testifying, out-of-court statements that are made under oath. So, with that, what I want us to appreciate here is that we need to teach our students that the packet serves double duty: source of personal knowledge for our fake facts and our fake witnesses, but also a source of evidence that can be used during the trial. And of course, the devil's always in the detail. How do we go about doing this? The general rule is that hearsay is inadmissible in evidence. And of course, the challenge is always, how do we identify hearsay? Anybody have any ideas? How do we recognize hearsay at trial? What do we listen for? Emily?
An out-of-court statement offered other than for the truth of the matter asserted that is not admission by party opponent.
Okay. Use an out-of-court statement other than while testifying.
I said not offered, I meant for the truth of the matter.
Offered for the truth of the matter asserted. Right. We'll get into the parts of the definition, but that is absolutely correct. So, how, as a trial lawyer, do you recognize hearsay in a courtroom while a witness is testifying? What do you listen for?
So-and-so said.
Okay.
Or,
Okay. Do that. Repeat that again, Emily. What are you listening for?
the word said, or if you say Kevin said, then that would be or told me, or I heard from so-and-so. Then
Okay.
that would all presumably be hearsay.
How about I read?
Right.
The point here is that in teaching hearsay to the students, the first challenge is recognition. And what they need to do is to listen very carefully, as Emily said, for the kind of cues that would give it away. So as long as a witness is saying, I saw this, I did this, we're okay with that. That's personal knowledge. But once the witness begins to say, so-and-so said this, or I heard this, or I read this, those verbs, read, heard in particular, will draw or should draw the hearsay flag. And why? Because the witness is no longer testifying, at least potentially, from her personal knowledge anymore. Rather, what she's doing is drawing in statements made by other people or other writings. But the point is statements made other than while testifying. So the real gravamen for hearsay, for present purposes, is that hearsay is a statement other than while testifying. So if we have this witness on the stand here, and she begins to describe other statements that were made, oral or written, before her testimony began, we've got a potential hearsay issue. So to kind of round this out, if a witness is quoting or paraphrasing some other human being, whether it is an oral statement or whether it is a writing, we have a hearsay issue. And what's your advice to students, lawyers, when the witness begins to say, I heard, I was told, I read? What do we do?
Objection, hearsay.
And does it need to be anything more than objection, hearsay?
It could just be objection hearsay, or if you wanted to, you could have them go into and say it's a statement that's offered for the truth of the matter asserted. But I usually just have them say objection hearsay.
Yeah, the two words are sufficient, objection, hearsay. And what happens at that magical moment is that the burden shifts on the lawyer asking the question, the proponent, to figure out a way around the hearsay rule. And that is often very difficult, especially if the trial's moving along like this, because there has to be almost an instantaneous recognition of the nature of the hearsay problem, and unless you've anticipated some of these things, it may be very difficult for the proponent to immediately respond. So what I want to emphasize here is that we listen for the witness quoting a statement other than while testifying. Usually, it's going to be a statement made by some other person or a writing made by some other person. But as we'll see in a moment, it could even be that witness's own statement, affidavit, police report, or whatever. Why? Yeah, they're here, they're under oath, but that statement in the affidavit or the statement in the police report was made other than while testifying right now. Again, we want our evidence fresh. Okay, let me come up for a breath here and ask you if you have questions at this point. Hearsay can be a whole lot trickier than than you might imagine. The easy examples are when the witness is quoting or paraphrasing. And as I said, what you may want to do with the students is to do some hearsay exercises where maybe what you want to do is to just start talking, let's say, through your day and tell the students that I want you to object to anything I say that amounts to hearsay. So you might describe your personal, of your personal knowledge, when you got up, what you did, but then begin to quote things that other people said to you. Or even, well, I turned on the TV and I saw that the debate tonight is supposed to begin at 8 p.m. And what they ought to be doing is saying, well, that would be hearsay because some announcer on the TV made a statement. Or you sat down and you read the the morning newspaper. Well, that too is a out of court statement, a statement other than while testifying. And the whole point here is to just give the students the drill of recognizing when hearsay crops up. Also tell them that the easy part is making the objection hearsay, because the real hard part is oftentimes figuring out how to get that hearsay in evidence, because most often it is going to be admissible. But it's usually really tough to figure that out. But that's not your problem as objecting lawyer. You say, objection hearsay. And all of the heavy lifting has to be done by the objecting attorney, okay? Now, when I said that hearsay can be even more subtle than I suggested, I'll give you one of my favorite examples of this. The law of evidence is, I'm actually delivering a paper on this subject at the University of Georgia Law School in January. And one of the central themes of my paper is that the law of evidence was really imposed upon a very unruly, amorphous common law trial where there were no real evidence rules, where people would come in and just kind of share what they know and even what they heard. But what the law of evidence decided to do is to try and give this more rigor, especially when the lawyers got involved. My point is that there are a lot of quirks in evidence law generally, and that includes hearsay. So as I said, hearsay generally is when we're quoting or paraphrasing someone else. Scott, since you're right up front, what is the month and date of your birth? August 19th, all right? Now, does that involve hearsay? Is he quoting somebody else? Is he paraphrasing? Yes, but he's got personal knowledge. You were present at your birth, right?
I'm told.
Yeah, that's the problem. He was told. Put to the extreme, the law of evidence would recognize as hearsay every one of us testifying to our birth dates. Why? None of us have personal knowledge. We're a little bit too young at that moment for personal knowledge. So what happened is at some point, who told you what your birthday was, Scott? Do you remember?
My parents.
Are you assuming that? Or do you have a vivid recollection of, yeah, I remember it was on August 18th of my 4th birthday that they said, hey, buddy, tomorrow's your birthday.
Before there were, kids now are going to say I have a photograph of my first birthday and the date's imprinted on it. But you're right. I have no present recollection of who told me that my birth date is August 19th.
Ooh, so what would happen in a courtroom? Anybody have any idea? I mean, just think about this. One of the first things we ask witnesses when they get on the stand is, state your name, spell your last name for the record, please, and then to kind of simmer them down a little bit to quell that anxiety, we ask them some background questions. First of all, it's good for credibility, good for the jury to learn a little bit about the witness, but it just kind of simmers them down a little bit. We might say, how old are you? Where'd you go to high school? Things like that. But that question, how old are you, involves the witness really dredging back and telling us about their date of birth.
Now, I can add that I've seen my birth certificate. Does that help me out?
Well, that's just another layer of hearsay, isn't it?
But is it admissible?
Is the birth certificate admissible? I can think of about 3 ways to get it in, but this is the problem in a courtroom. Objection, hearsay to birth certificate. darn it, what do I do? How do I get that into evidence? You could turn to the other lawyer and say, hey, stipulate to the birth certificate, and hope you catch a break there. But I know as a trial lawyer, and I tried probably well over 100 jury trials in my time, is whenever anybody asked me to stipulate to something, I always thought, they're not making life easier for me. So it's an adversary system, so we'll play it out. The short answer is we have, believe it or not, we have a hearsay exception for birth dates. And it is a part of what we call personal or family records. So, for example, Scott, you mentioned that you have, do you have siblings, brothers, sisters, too? Older or younger? All right. How do you know they're your siblings?
Come to think of it.
But this is how crazy the law can be. But the point is that if Scott were in a court testifying, how old are you? Oh, objection, hearsay. You have any siblings? Well, I've got 2 older. Objection, hearsay, because the only way he'd know that they were his siblings was because somebody, them, mom, dad, uncle, aunt, who knows, told him that they were his siblings. So we have an exception for family statements of family history. And the way the hearsay rules are structured, there's really 3 groupings of what I'll call exceptions. There's this first group that is clustered around admissions by party opponents, which I'll talk about in a moment, but also involve prior statements by witnesses. And then there's a group of about 23 exceptions that fall under this general heading of unavailability of the declarant not required. And that's just, it's technical, but what it drives home is that there's a category of 23 exceptions which are deemed to be so reliable that we don't care if the declarant, the source of the hearsay, is testifying, and we don't care if he's not. Just makes no difference. And then we have a third grouping where we require as a predicate that there be a showing that the declarant, or more accurately, the declarant's testimony, is unavailable. So one form of unavailability might be the death of the declarant, or a declarant we just can't find, even though we're looking for the declarant. Or in some cases, the declarant can't remember or has no personal knowledge. And that would be our example of the birth date. None of us have that true personal knowledge of either the moment of our birth or, for that matter, the exact time we were informed by mother, father, siblings, whatever it may be, what our birth dates are. But I assure you that there is a hearsay exception for things like family history. There's also a hearsay exception for stuff like, and this is, a lot of law of evidence arose in Victorian times, and so you'll see exceptions for the family Bible, for example, or for the family portrait that would have been painted and put on the wall with a faceplate of who those family members are. Even like a high school class ring or a college class ring, there's an exception for that. Yes?
How well is that family portrait thing going to hold up when this is made with Photoshop?
You know what? I'm sorry, I have trouble hearing generally, but I didn't hear all of that.
I put a microphone. How well is that family portrait as evidence going to hold up in the age of Photoshop?
Oh, good, very good question. And the answer is, my subject is hearsay. That's an issue of authenticity. But it's an excellent question, because I've talked about this with the judges, because we live in a day and age of Google and the internet, and judges are constantly being asked to take judicial notice of all sorts of things, and they want to take judicial notice because it's an evidentiary shortcut. The problem is there's a lot of great stuff on the internet, and there's also a lot of junk and stuff that's unreliable. And you're absolutely right. Photoshop has become a verb form that I think puts all of us on notice that there could be real problems with certain things that we read or even see on the internet. One thing I did with the judges this last summer is I went to, I had the computer open, and I went to Google Maps, and I hit satellite imaging, and I did the overhead of the new Marquette Law School, Eckstein Hall, on the corner of 11th and Wisconsin. And I said, yep, it's right here. And I said, we all have personal knowledge of that. We could testify to it in a civil case. A judge could take judicial notice of it. And I said, you want to see something neat here? And so we were all looking at the overhead satellite image of the law school. And at that time in June, what I did is, you know the street view function where you drag that little character down there and hit that button? I did it, and presto, guess what? No Eckstein Hall. The street view images had been made, actually they hadn't even begun to dug the hole yet. It was the old green Tory Hill, which would become the site of the law school. But I said to everybody, I said, if let's say this was Dusseldorf, Germany, and we're taking, we said, well, where is this location? And we looked at that overhead image, and then we went to the street view. We'd have no knowledge about whether, which one of these images is reliable, except by reading the hearsay that Google affixes to the bottom of the to the bottom of the image. So the point here is simply the first thing to do is talk to them about recognizing hearsay, but also why it's important that we recognize hearsay, because this is the teachable moment. Is that when a witness is testifying to personal knowledge, or what we're going to assume is personal knowledge, we're comfortable with that because they're under oath and we can examine and cross-examine the witness. But when they begin to quote an out-of-court statement, particularly by somebody else, we don't have that same level of comfort because we don't know whether that other person's observation was correct necessarily, or whether it's a lie, or whether it was misperceived or misdescribed, or what have you. So as I said, the initial challenge then is recognizing hearsay. Most hearsay, as I indicated, is, however, going to be admissible. And here what we want to do is to begin with a definition of hearsay. As Emily indicated earlier, it is a statement by the declarant other than while testifying offered for the truth of the matter asserted. The first thing we have to do is to start with a definition of statement, because statement is by convention an assertion of fact. So whether it's an oral statement or a written statement, it is fair game for hearsay if it describes some fact. It was raining or whatever, no matter how mundane. The other part of that is it has to be made by a declarant. And under the rules of evidence, a declarant has to be a human being. All right? So drug-sniffing dogs, not human beings. So if the witness testifies that the drug dog alerted at the apartment, so what? That's not an interesting hearsay issue at all. If I don't have a watch, but were you to look at your watch, or even better, the 21st century pocket watch, which is the cell phone, is if we take a look at anything on our cell phone, it is certainly a statement in a sense of information that we can read, but not necessarily hearsay. Why? Because this is not a human being. This is a machine. And so one of the challenges now in the 21st century for the law of evidence is dealing with so many of our machine-generated statements. And what the courts have done, and they're struggling with this because it is so subtle, is to distinguish between a machine-generated statement, like let's say the time on that clock on the back wall, or the time on our cell phone, a machine-generated statement, and a machine-recorded statement. So, for example, if somebody's taking notes on a laptop and keys that in, that would be a statement made by a declarant, which happens to be recorded on the computer. So, part of this is dealing with the definition of statement by a human being, the declarant, other than while testifying. And here the timing is critical. for purposes of trial, the magic moment is the first minute of the trial. Any statement made other than before that, or other than in the courtroom itself from the witness stand, is subject to a hearsay objection. And it's only hearsay if it's being used for the truth of the matter asserted. And that's another way of saying, well, if I'm not offering it for its truth, then it isn't hearsay. Is that right? And that's absolutely right. And so what it does is it gives me as a lawyer, an out. So I'm offering, let's say, an out-of-court statement. You object on grounds of hearsay. I respond, I'm not offering it for the truth of the matter asserted. Hearsay, done. We're finished. Why? Because I control the purpose for which my evidence is offered, and I have declared that I'm not offering this for the truth of the matter asserted. We're done. No need for a hearsay exception. The definition of hearsay is not implicated because it's being offered for something else. So one of the things to talk about with the students is, isn't that the facile way then to get around all hearsay objections? Just say, I'm not offering it for its truth. And the answer is yes, it always works. Yes?
Can you give an example of when you would ask a question and then defend against the objection by saying that?
What would be the objection? Hearsay, and then my response is I'm not offering it for its truth?
Right, like what would be an example of the question that you asked?
I'm glad you asked. And this was not an audience plant, by the way. If we take a look at Detective Agos' statement, and we take a look at, what is it, paragraph 12. You know, one thing I love about this problem material is very, very well written. A lot of creativity went into it. And one of the things that I really liked about Detective Agos' statement is his annoying personality just bleeds through this statement. I mean, he constantly refers to the defendant as the perp, for example. But where I'm going with this is if we get into paragraph 12, is, let's see. Oh, I'm sorry. That wasn't the example I was looking for. Look at Rashawn Anderson's statement at paragraph 8. It would be on page 2 of the affidavit of Rashawn Anderson. And look at that very first sentence. Ma'am, do you have that in front of you? Yes. Okay. And if you were testifying as Rashawn, what would your testimony be?
For paragraph 8?
Yeah, just read that first sentence in paragraph 8.
I never had a problem with Muncher, but I heard from my friends
Objection, hearsay. Heard from my friends. All right? Out of court statement. All right? Who are the declarants? The friends. Not named, we don't care that we don't know who they are or they're otherwise unidentified. They're still somebody else. But I heard from my friends that Muncher had a problem with me, right? So objection, hearsay, and then what the judge would do is say, counsel, the proponent, and how might we get that in? Or can we? Okay, offered as background. And by the way, you tell your students that when somebody glibly responds, not offered for the truth of the matter asserted, the next objection should always be irrelevant. All right, so objection, hearsay, not offering for its truth, then I object, it's irrelevant. All right, so background, convince me that this is relevant to background. You're on the right track, but how is it relevant to background? Okay, how?
This guy's going to be coming to you with a problem that they have.
All right? Or to put it in hearsay parlance, this is being offered for its effect on the listener. So we're not offering it for its truth that, in fact, Muncher had a problem, but for the effect that it had on Rashawn. That is, he was told that Muncher had a problem with him. So we don't care whether or not Muncher really did or did not have a problem with this guy. What is relevant is Rashawn is thinking that this guy has a problem with him. So what it illustrates then is how we work with the definition of hearsay, and that it's a statement other than while testifying by a human being offered for the truth of the matter asserted. And it can be offered for other purposes, but they have to be relevant, and this is a nice example of effect on listener. What would be another way of offering a statement for a non-hearsay purpose? Anybody think of another common ground, Scott?
Police call?
Which one now?
A police call?
Police call for, okay, that'd be effect on listener as well, why they responded.
Explain subsequent behavior, yeah.
Right. And so we have two good examples of effect on listener or even the reader if we'd read something. Another one is declarant's state of mind. So that what we're doing here is saying, look, so-and-so made the statement, but we're not offering it to show the truth of the fact asserted. We're offering it only to show that the witness believed it to be true. So, and assuming that is relevant, and it's almost always going to be in an impeachment context, then it would be admissible. So that's it's important then when we work with this definition of hearsay to deal with all of its components. And you know what? It is complex. And you know the judges are challenged by it, the trial lawyers are challenged by it, and the high school students will be challenged by it as well. Although I suspect they just carry less baggage than we do, so they might not make it as hard as we make it out to be. So, but questions about the definition of hearsay? Nathan.
This goes back to the definition of statement. I did this once in court and it worked, so I've been telling the kids to do it, but I'm not sure if it's right. It was along the lines of I heard somebody say stop, and the argument would be it's not an assertion of fact, it's incapable of being true or false, it's a command, so it's not a statement. Is that true?
Yep, that would be right. That would be an example of an imperative statement. So we'd punctuate that with an exclamation mark. Or what we would do is another verbal form that is not a statement would be a question. So if it's like, well, tell us what happened, or can you tell us what happened, question mark, there's no assertion of fact here. But if the question is rhetorical, tell us, would you, let's see, I have a question about why you killed that guy. Well, or a question about why you shot him. Well, that contains an assertion of fact, so it's largely a rhetorical question. So, and again, they have to recognize this on the fly at trial, which makes it very, very difficult. One of my favorite examples of that kind of rhetorical question is there's a Wisconsin case where there's a head-on collision. Passerby comes on the scene. The one person is dead on the scene. The guy driving the truck was coughing up blood. It turned out he had just moments to live. And the bystander walks up to the truck driver, and the truck driver says, and you know, in the moments before his death, he said, "The guy swerved into my lane. What else could I do?" We'd punctuate that conventionally with a question mark, but I think we'd all realize that, nah, that's more of a declarative sentence that we would punctuate with a period, which is, by the way, how the Wisconsin Supreme Court punctuated it when they described that oral statement. And while it was certainly a statement, and while it was certainly offered for the truth of the matter asserted, Supreme Court said, this is easy, because it's either coming in as an excited utterance. So one of the exceptions that your students will have to look at, and that is also applicable here, particularly with Rashawn's statements in the ambulance, is that whatever he did say, and of course there's a dispute about what he said, is those are excited utterances. Why? Well, what could be more exciting than being shot? And as long as a statement relates to the startling event or condition, and he's under stress, which he certainly is while in the ambulance, it comes in as an excited utterance. It can also come in as a dying declaration. As I recollect, what we have here is, this deputy sheriff, Morgan, what's his name? Morgan Marshall, right? Morgan Mansfield, I'm sorry. Morgan Mansfield, and this is paragraph 8, is according to Mansfield, he said, while in the ambulance, and I'm reading here from his sworn statement, Anderson, Rashawn, told me that, quote, Puncher did it. I am confident that I heard Anderson say Puncher with a P. Now, the difficult hearsay problem presented in this case is that this is Rashawn's own statement, and Rashawn will undoubtedly, make me sure. I got to make sure that I remember the trial and who's going to argue what. But where I want to go with this is, tactics aside, is that this could come in under a couple of different exceptions. One would be the excited utterance for reasons that I said before. And another way it could come in is perhaps, this would be trickier, perhaps as a dying declaration. Now, we know Rashawn didn't die because this is only an attempted murder case, but he was shot, and there is some evidence that he thought or was afraid that he was dying. In fact, in the preceding paragraph, he says, am I going to die? And he looked pale and had a hard time focusing. Is what the dying declaration exception requires is simply that the witness have a belief that he or she may be dying. Now, again, this is problematic because in Anderson's own statement, he says, I don't know what I said. I don't remember having said anything. So probably it's going to be through Morgan Mansfield that statement would come in, depending on whether anybody wants to offer it in the first place. But the larger lesson here with hearsay is if you are offering that statement and you're offering it for the truth of the matter asserted, then the hearsay rules really form your grocery list. And what you do is you go through them and you look for anything that works. So again, to go back to this statement made by the defendant, Rashawn, is one very, very handy exception, and I'll call it that, is admission by a party opponent. So what the government can do here is to put in any and all statements of Rashawn Anderson as admissions by party opponent. Why do they get to do that? Because that rule says they can't. Because it's state versus Rashawn Anderson. The state can use Rashawn's statements against him as an admission by a party opponent. But as I said, there are other exceptions that work here too. Dying declaration, excited utterance. So which one works? The answer is, hey, anyone that the students choose. You only need one exception to work, and you can put the statement in for its truth. That.
Excuse me, Professor. I think
What?
you may have mixed up Rashawn and Leslie St. Peter. I think you meant to say Leslie St. Peter.
I'm sorry. Oh, Leslie St. Peter is the defendant. I am sorry. So since Rashawn, why did I think Rashawn was the? Well, it doesn't matter. My confusion is. Rashawn is since he's not named party, and this is another teaching moment with admissions by party opponent, is you turn to the complaint, the pleading, and you say, State of Wisconsin is the plaintiff, Leslie St. Peter. So the only person in this case who will be making an admission by a party opponent will be Leslie St. Peter. So it will only be his statements being used against him. So that's why we have an affidavit from Rashawn Anderson. He isn't the defendant. All right, that makes sense to me. So, but otherwise, you can get in some of those statements too as admissions by party opponent. And Rashawn is the shooting victim. And you might say, well, isn't he then a party to the action? And the answer is, heck no. He's just a victim. He is just a witness for purposes of the law of evidence, so he doesn't have any privileged status. So what the students are going to have to do here is to work through the material and to figure out tactically, strategically, what statements, oral statements that are around the time of the crime or before the crime, or even the later sworn statements might help their case, and which ones they want to put in for the truth of the matter asserted. And then what they're going to have to do is anticipate hearsay objections and look for possible rules and exceptions that would permit them to put those statements before the jury. So it's 3:02. I'm going to stop here for any questions you might have, because I know that you're on an agenda and you have more to do. So questions, hearsay? Yes.
I must have missed somewhere along the line when you said there are 3 groupings of exceptions. Could you just run through that one more time? The 3 groupings of hearsay objections?
Oh yeah. Is this being, Ellen, is this being tried under the Wisconsin rules or the federal rules of evidence?
The rules that we use are pretty close to the Wisconsin rules. They're not 100%.
Yeah.
We've changed a few, and I don't remember if any of them involve hearsay.
Yeah, there's 3 clusters of hearsay exceptions. Some are found in, and I don't know, I haven't seen the rules of evidence, so I don't know how they're numbered. But in the first group, you'd have admissions by party opponent. So again, anything said by the defendant in this case, Leslie St. Peter, would come in as an admission. You then have 3 rules for prior statements by a witness. So if the witness says something in court today, but is inconsistent with what he said earlier in an affidavit, or let's say an oral statement to the cops, it can come in as a prior inconsistent statement, either to impeach his credibility or for the truth of the matter asserted. Because the idea is, if the witness is saying A, B, and C today on the stand, but earlier said X, Y, and Z, that's inconsistent, and we shouldn't put much weight on his testimony. So that's that first grouping. You then have that much broader grouping of 23 exceptions, which spans everything from excited utterances to business records to family records. And then you have a third cluster where we require as a predicate that the declarant or the declarant's testimony be unavailable. And the only one applicable that I can really think of would be dying declarations in this particular case. Otherwise, nothing really jumps out as maybe a statement against interest. It's another one, but again, I don't know which ones are going to be included in the packets as fair game for use at trial. The other thing is, and I think this is just something you mentioned to the students and then drop it, is this is a criminal case. And yes, it's governed by the rules of evidence, but since we're talking hearsay, it's well for all of us to know that there's also the Constitution that comes into play. And there's something called the confrontation right, which is so enormously complicated that this last spring, when the U.S. Supreme Court took up this bombshell case involving the confrontation right and the use against a defendant of hearsay evidence, the court split 4-1-4. In other words, no commanding opinion in that case. If you're just literally confused if you read the opinion. So there's also this confrontation right out there, and I'll talk to the public defenders next month about this whole subject of confrontation, because what I tell them is that competent criminal defense lawyers will not only object on hearsay whenever the government's trying to put that in, they will automatically object on confrontation grounds as well. Unless there's something in the guidelines that I'm unaware of, that's good background, but I would not try to introduce that complexity. Ellen, you concur?
Confrontation is not one of the objections we allow in mock trial, but I was wrong. I looked it up. It's based on the federal rules.
Federal rules of evidence? Okay. Fair enough. Okay. Other questions? Otherwise, thank you very much for your time and patience. Oh, I'll talk to you. Oh, okay.
The one way of trying to get around the hearsay answer from a witness that is standard by lawyers and judges don't understand is, well, do you know what happened to, or do you know what happened to this person, without indicating that they're asking really for personal knowledge. And a lot of times, well, the judge will say, the witness can answer if they know.
Yeah,
And
well,
then
the
the
problem
witness
is,
will
is
relate
that
hearsay.
if they haven't seen it themselves, if they've only heard it or read it, then they don't know.
I know.
And then the objection would be lack of personal
Personal
knowledge, which is sometimes coupled with a hearsay objection.
Yep.
You know, the interesting thing that you have in this problem is the victim, whose name I keep forgetting, the victim of this case is can't recall that statement that's attributed to him in the in the ambulance. So what you're going to have is a conflict potentially in the facts about did he or didn't he say it, and that'll be for the jury to sort out. What, if anything, did he say in the ambulance? Or is that detective simply making it up, or did he mishear it or misremember it? But that relates to credibility issues, which you can take up with them as well. Other questions? Otherwise, thank you very much.